Thank you very much, Sammy. And good morning, everybody. Can you all hear me? Okay, so some housekeeping rules. If you have to take a call, please go outside. Put your phones on silent, please, and no side talking. You can write or message yourselves, and so that you can listen to us. We flew in, and so we need to be listened to. And then we would want to hear from you because this is really important. As Prof has set out for us and from the keynote, the question really for us is, yes, with all that is going on and all that we have been told, how do we then, as arbitrators, as those who act as counsel, as Africans, how are we going to make our voices heard and felt? It's not enough to just keep talking about the data. The data is the data. It's there. We all know. But the question then becomes, how are we going to move all of that in the direction that we want? And how are we going to know when the needle starts moving? When it moves from 4.8 to 6.5 to 10%, what does that mean? And how would we identify that? That's what we've heard. So for us, our own panel is going to start the conversation today, and our panel is going to be looking at the impact of digitalization and AI on arbitration proceedings. With the new context of where we are, what does that mean for us? How can we better prepare ourselves? Can we leapfrog? What are the challenges? What are the opportunities? So you're not going to be hearing a lot from me. You will hear from me, but not a lot because you're not here to hear me speak. I have 3 speakers. And this panel, luckily, we have 1 male. He's very lucky. And because we had said, since the welcome thing is a men's affair, we were going to have a female affair. And Louis, you're most welcome to the panel. So his name is Louis Peacock. I hope he's looking like he's scared of me, like I have to behave myself. Anyway, so Louis Peacock Young is a senior associate in the international arbitration team at Stewart's. And he has written here, the UK largest disputes only law firm. I would pretend I didn't see that. And he works with Daniel. Daniel was meant to be here, but unfortunately, personal reasons, he's not able to come. And so he loaned us his senior associate. Is this your first time in Africa?
Not first time, but first time for some time.
First time, where else have you been to?
I've previously been to Egypt, but when I was much younger.
So this is your first time?
Yes.
Yeah. And then we have next to Louis, we have Salma. Salma is a senior associate at Riscana and Partners. And she specializes in dispute resolution and arbitration, and she is also an RICS. What does that mean? What's RICS?
The Royal Institute of Chartered Surveyors.
Yes, accredited mediator. So she's are you a surveyor? Are you a surveyor? No. Okay, so
I get accreditation for mediator and arbitrators as well, not just surveyors.
very good. Okay, so she's a lawyer. And we then have Chinecherem Nwa Ubani, and she's a senior associate in YC Mekiao and Co. Was it? I met you in Abuja. Yes, now I remember. Which is also a full service law firm in Nigeria with offices. Okay, there is no point. That's my panel. And what we want to do is we have a couple of questions which we want to engage with. And it's going to be discussive. So we are not going to get, you're not getting one person giving you a long speech. We want it to be interactive. Now, if you have questions, that's absolutely fine. If it's burning and you have to ask it, you can raise your hand and interrupt us, and that's fine. But don't make a speech because you're not a speaker. You're meant to be listening to people speak. So please, or you write down your question and then you do ask a question. If it's not, a question is the one that ends with a question mark, and then you ask the question. Don't build the context. Okay. So, Louis, we want to start with for you to give us a sketch of the context. So when we speak of AI or technology in arbitration, what exactly are we talking about?
Thank you very much, Professor. There's a diversity, one might say a proliferation of products which now use the term AI to describe themselves. Sorry, I'll speak to the audience. There is a temptation to treat all of those products and tools as standing and falling together collectively, but it's probably better to consider by product or task or use case. Each product or task carries with it different considerations, and in this regard, I think the term AI tools, which is a term adopted in various forms of guidance, for example, the Chartered Institute of Arbitrators guidance from earlier this year, or the Silicon Valley guidelines. AI tools as a term is helpful because it implies an analysis which is task-based. So what do these tools do? And I'm adopting here some definitions from the VAL's legal AI report. This is a benchmarking system. Many may be aware of it. It categorizes by output. So data extraction, summarizing documents, interrogating documents, for example, asking a question about a contract. Can this contract be terminated for breach? Preparing chronologies, a tool for legal research, note-taking, translations, and then two forms of products which combine some of these aspects. AI agents. So these are tools which will allow for multiple research steps with the user interacting with the AI to produce iterative outputs, and AI assistants, something such as Copilot, which you might consider a more administrative role. There's a wider technological framework which applies in arbitration. You have counsel, arbitrators, institutions, servers, systems, document sharing platforms, research databases, electronic bundles, virtual hearings, and then the products expand this ecosystem. You end up with the data going to the provider and the AI models on which these products are based. And that raises certain questions about whether the prompts or the data enter into that ecosystem, whether they may be reproduced elsewhere.
Salma, what do you think?
So before we dive into the intersection between technology and the role of AI arbitration, I would like to begin with an observation. So I would like to begin with an observation that is simple but important on how quickly technology has an impact on the legal sector. And I would go back to 2016 and share a McKinsey released, where McKinsey released a report on the impact of AI on the legal sector, estimating that 50% work activities will be automated somehow between 2035 and 2070. After 7 years, especially in 2023, McKinsey updated that forecast, stating that they now expect that this level of automation, which is 50%, will be happening sometime between 2030 and 2060, my apologies, which is a shift that accelerated the timeline by about 10 years. This is just one signal of how quickly things are moving and why the legal sector needs to think not in decades, but maybe in years when it comes to arbitration and AI. Now, back to the core question, what are we speaking about when we talk about AI and arbitration or technology in general? We are referring to a large ecosystem of platforms, tools, apps that has an impact on nearly each and every stage of the arbitration life cycle, as we were just saying, starting from the case preparation, generated timelines, legal analysis, document draft, award drafting, legal research, document review, remote hearings. So affecting each and every phase of the arbitration case. If I would take just one example, and I would say of these tasks, which is the legal research, and have a very quick look on these tools and apps used to assist in generating outputs. I would group these apps generally, and this is based on my very own practical perspective, not a technical expert, in two main groups. The first is the general AI platforms that rely basically on public available information like ChatGPT, Gemini, Claude. And these platforms are trained to on, I would say, vast amounts of internet data and generate the responses based on available resources. The other group is the specialized AI platforms, which is, we have several examples like Swansea, Lexis Plus AI, and others that are tailored particularly for the legal and arbitration field and generate that databases based on structure, data coming from arbitral awards, commentaries, articles for decisions, and other. So the main purpose of this key distinction is to highlight that the level of accuracy of information is completely different, taking into account the loopholes that Professor Abdelwahab was just mentioning, even for the specialized AI platforms. And we have other examples for selection of arbitrators like the GAR, the conflict checker for of Swansea, like the LCIA challenge database, which assists parties to have a look on the arbitration relationship existing and past, and to which extent they can challenge. And I want to take longer on this. Thank you.
Thank you so very much. So before I come to Chinecherem, just so that you don't repeat what has been said, I'm coming to you with a different question. What we've heard so far is been this whole idea of enhancement and supporting the work that lawyers effectively do. So platforms, tools, thinking of these AIs as tools, I think using data and data extraction, which means you can only extract what you put into the tool to extract, it has to be put in. And one of the questions that I might want comments from the group is the cultural impact or soft diplomacy. Where is this data coming from? So if you're using ChatGPT, which is a large language model tool, where is it platform? Where is it coming from? Where is ChatGPT getting its data from? How is that impacting the way we all do things and what we think? And so is that data coming from the continent? Is the continent providing that data? So Chinecherem, what is your view? Well, what do you think about the context? And maybe for you to just move on to what are these core values in arbitration that we're sort of engaging with and thinking about?
I got the question.
No, I said, so the core values in arbitration, what is it that we're trying to think about, we're trying to support, we're trying to work with, we're trying to be careful
Okay.
with what, yeah.
Okay. So arbitration has some core principles. We know, all of us know about the principle of neutrality and fairness. We have confidentiality. We have that of diligence. And the question is, how does the deployment of AI and tech affect these core principles of arbitration? Now, AI outputs, they give a semblance of being neutral, but the truth is that they are usually affected by their inputs. They suffer a kind of bias based on the inputs. For instance, if an AI is trained primarily in the Western jurisprudence, it's not going to be able to recognize some of the nuances of the African context, like we have in Africa some informal contractual relationships, the way we do things. So AI is not going to recognize that if it is trained in the Western jurisprudence, and some other sort of biases that were imputed in its data set at the point of training. So while it gives the semblance of being neutral, it is really not. Then there is the problem with confidentiality. So we know that we all want to get quick fixes from the AI, and you impute your data into it, you get pleadings, you feed it into it, you get facts and feed it into it to get quick outputs. But some of these things we are feeding into it are confidential information. And how are they being stored? How is it going to be repurposed? And there is the issue of the data breaches and hackings and all that. So these are the problems that arise with the use of AI in arbitration. Nobody, well, people think of it, but we don't really think of it. Sometimes we are just quick to, put in this information, and we don't think about how they are going to be used at the end of the day. And then there's the issue of diligence. So it has been said that when you're used to using AI, you do not realize that you are becoming subject to the machine. And so you start having that bias towards the machine's judgment. You are not able to, your own judgment becomes dependent on what the machine gives. And whether we like it or not, these machines are not perfect as they appear to be. I'll give you an instance. 2 months ago, I was writing a paper and I was almost done with the paper when I realized I was missing an aspect. So I quickly wrote something, and then I asked my son to help me. I was doing some other things, say, feed it into the machine, tell it to give you authorities on this, and make it. So he gave all the necessary commands and warned it, we don't want fake authorities. And then it comes out with authorities. But what caught my attention was, it was on administrative law. And one of the authorities was an authority that was as far back as when I was in school. I said, if this authority was existent, then why didn't I ever come across it? So I decided to go through all the authorities. One of them I recognized, Jack and University of Maiduguri. And then I said, let me go through everything. Well, it didn't give us fake authorities. It's just that none of them had anything to do with the thing. They were real cases that had absolutely nothing to do with what I was talking about. And then again in August, while we were at the Nigerian Bar Association conference, so I saw somebody, I said, this is the past general secretary, but I can't remember when he was the past general secretary. So I put in list of past general secretaries of the Nigerian Bar Association. And it gives me a name, two names. Both of them were past general secretaries, but then it adds an information. Emeka Obegolu, past general secretary, current president of the Nigerian Bar Association. I said, I know the guy is not the current president of the Nigerian Bar Association, but what happened? The guy was the chairman of the conference planning committee. And so for the past few months, his name has been coming up as chairman. So it interpreted it as him being in charge and interpreted it as he is the president. So the fact that this machine gives that semblance of being efficient makes us defer to it, but we shouldn't. An arbitrator's duty of diligence must not be tampered with. These machines are there as assistants. And just as you go through what your junior in the office presents to you, that must be how you are going to interrogate everything these machines put forward. Because I can tell you, a lot of times, they might be subtle, but they give false or wrong or not exactly correct information, and you cannot afford to rely on them totally. Thank you very much.
Thank you very much. And so a couple of things, no clapping, we haven't finished. Sorry, we're on a very strict time. So we want to, and we have quite a lot we want to talk about. And so one of the things Chinechere has pointed to is not just the fact that the AI might give you information or seeming information, and Louis also mentioned that stuff around credibility. We do have a research out of MIT where they had done proper research with the methodology was there, but very few sample. And the finding is when you depend too much on AI, your brain function reduces. Because for the brain, you use it or you lose it. And so and just think about it. I'm just sort of trying to think of some mechanical thing we do now, you punch in numbers. How many of you learned the times table? How many of you even know what a times table is? Yes, so it's only the oldies in the room. And so you know your two times 1, 2 times 3, and automatically your brain rewires itself that way. Now, for those who just have computers or calculators and you just punch it, you don't know. Your brain can't function. But some of us, you can slap us awake and we can tell you the times table all the way to 12 because you had to learn it. And it's there. And I think that's what they're trying to say. And that's the point Chinechere is making. So yes, you have to add the correct prompts. But what the panel is saying is, don't just add the prompts, accept what it comes out with, but interrogate. And that research says that when you interrogate with the machine, you build a relationship with the machine and the output. And then that helps your brain function. So remember that. And so turning to Salma. So what sort of possible risks are we seeing or we may see?
The confidentiality, this is one of the main risks, because I'm sitting today on a panel speaking about AI in arbitration, and until today, I can't insert a single confidential information in any of these platforms because of the simple reason that it's we don't know where is data going, who might have access to this, and whether is it protected or not. So regardless how impressive it is. So I checked some of the demos showing how timelines can be generated just in a few seconds, and I was quite impressed. I thought how many hours I spent doing these timelines. So it's really impressive, we can't deny. But it's very risky, and we can never forget that one of the main incentives of arbitration is that it's confidential. So we can't lose this main incentive. In my view, for the confidentiality, we need to have protocols, technical safeguards, and institutional guidance, so that we can ensure that the core of value of confidentiality is not compromised as we embarrass innovation. This is one thing. The other is the accuracy of the generated information. We have seen recently many lawyers facing sanctions because they are relying on incident that does not exist, on citation that is not correct, as we call it, it's hallucination, especially from ChatGPT. So this is another main risk, and as we are just confirming, if we started relying too heavily without proper verification, we risk undermining the integrity of the process. This is one thing. And the oversight of human, I would say, oversight needs to remain central, especially when it comes to verification of information feeding the decision making.
Thank you very much. Commissioner, did you want to say something before? Yes, okay, before I come to you.
Okay, apart from the risk of possible attacks, hacking in 2015, we know that the database of the PCO was hacked while a very high profile case was going on. Apart from all those, we have, apart from hallucination also, there's this problem of psychophancy. These machines are trained to be psychophants. In fact, in April this year, one of a user posted on social media, he said, AI becoming too psychophantic, notice Gemini 2.5, praising me instead of solving the issue. In fact, some people have nicknamed the AI the digital yes man. So it tells you what you want to hear. In April also, I think ChatGPT had to withdraw a particular update. That is the GPT 4.0. They withdrew it because they said it was overly agreeable and flattering. I want you to see the emphasis on overly. Not that it was flattering and agreeable, but overly. That tells you that all the other ones are also agreeable and flattering. So that is a risk, because these things are telling you what you want to hear, not necessarily being accurate, not necessarily being correct, but you know. And I think somebody mentioned that it's because people also use it for affirmation and all that. So it has to be politically correct to a great extent. So that is a risk.
Which is really interesting and a good segue to Louis, coming to Louis to sort of engage with knowing all of these risks. What are there any opportunities? What is it? How should we actually use this professionally? And people use AI in their personal lives. I hear that there are AI wives and AI husbands. So if you don't have one and you can't say hello to people, you can negotiate with an AI. But this is happening, and that is the future. So how do we and we also engage with this whole idea of being overly polite? I use Copilot. We use Copilot at work. And when it finishes, it says, would that be all, Professor Onyema? And I say, yes, thank you. And it says, you're welcome. And because that's the way we talk to people. If somebody gives me something, gets me something, I say, thank you. And there was some person that was saying that why the ChatGPT people and Elon Musk and co do not want us to say thank you is because of the energy that the AI uses up. And so that also has implication for the environment, climate change, renewables, the power source for those. Louis.
Yes, I would agree with everything that's been said so far as to the risks. And I think we were talking about the principles of arbitration, which the use of AI tools engages. And when you think about each of those things, I think in some cases you can see it cutting both ways. So one thing which I considered was, sorry, is that better? One
He's very tall.
An aspect which I considered, and I'm sure others have considered as well, is the centrality of independence and impartiality to the arbitral process. The use of AI tools in the course of making a decision could impact on that. So if you take the test for independence and impartiality of an arbitrator, which in part has an objective test of whether a third party would have justifiable doubts that there is a likelihood the arbitrator may be influenced by factors other than the merits of the case. That goes to a point which has been made by Professor Onyema, by Salma, and by Chinachira, which is the AI tools rely on models which are trained on a particular data set, which is provided to them, which isn't strictly going to be the facts of the case. And when it comes to this, then do we assume that it isn't independent? And if so, is there a call for a regime to be put in place as to how an arbitrator would use AI during the arbitral process? In this regard, the guidance, I think, recognizes this possibility. So, for example, the CIR guidance from this year encourages consultation with the parties about the use of specific AI tools before early in the process, and in conjunction requires limitations on the use of AI that could influence procedural substantive decisions. I think this goes to the concerns that have been expressed. But the other side to that coin of impartiality and independence, when we're thinking of positives and opportunities, is there a possibility that the use of an AI tool could contribute to better fairness perceptions in respect of certain decisions which are made in or which affects the arbitral process? For example, could the use of an AI tool be used to challenge groupthink or received wisdom in respect of certain conclusions or decisions that are taken? For example, if a party is choosing an arbitrator, might the use of an AI tool provide an alternative which is free of the parties and their lawyers' pre-existing expectations and ideas as to who would be appropriate? So the short question is, does it provide an answer which is free of cognitive bias rather than reinforcing pre-existing ones? My understanding is that there are certain arbitral institutions which are already developing this.
Great. Chinacharam, did you want to add to what Louis has said about possible opportunities?
Possible opportunities. Of course, there are opportunities that the use of AI presents. I mean, speed and efficiency in arbitration, effective case management, virtual hearings, and all that. And then these machines are going to be trained. And we are talking about using it in our African context. And we keep complaining about how machines trained in the Western world cannot really serve us. So lawyers can start looking, or arbitrators can start looking towards being involved in the training of these machines to suit our own local context, so that we stop complaining about how they are not serving us properly and actually have something that is bespoke that will serve our own local needs.
That's an interesting suggestion. Thank you very much, Salma. And again, in the African context. So.
One main positive insight here is the increase, of course, of productivity, again, without the compromise of quality and ethical duties as well. And I would like to share another risk that I see also very important, which is the risk of predictive outcomes. We are now seeing features in platforms that can predict the outcome of the disputes. And on the surface, this can be helpful for the parties to have the sense on where their case stands, how similar cases have been decided. But the point here is that arbitrators are expected to approach each case on its own merits. And if we have the sense of having these expected outcomes by time, parties might feel that their case will be prejudged by data, not by facts and law. And the related issue here is that we don't have clear guidelines on the disclosure arbitrators in the use of AI, taking into account that some of the regulations like or the guidelines like the Silicon Valley Arbitration and Mediation Center guidelines on the use of AI expressly stated that it's not a must for arbitrators to disclose that, or counsels to disclose that they have used AI. So I will leave the challenge to the audience.
Okay, great. Thank you so very much to members of the panel. We want to hear from the audience and then we'll come back to the panel. Do we have a microphone going around? If we do not, okay, please, let's start with, so we'll work our way this way. Yes. So the rule before you came in was just ask a question.
I was here.
Oh, good. Go on.
My name is Godson Ugochukwu. I'm from Nigeria.
Thank you.
Do you think, to what extent, if any, would anonymization of data before you upload help with the issue of confidentiality?
Okay.
That's one. The second one, I'm just asking questions. The second, and that's all. The second one is, given that the best intentions may not always yield the best results, should we now begin to think about contingency insurance in terms of data breaches for arbitrators and practitioners? What more about professional indemnity? Thank you.
Thank you so very much. Second, and then third. Second, can you please give the microphone to him? So to ask a question, and then I come to this side of the room.
Osman Sule, SAN.
Yes.
And Salma just stopped at a point that says that you don't need to disclose, use AI. And AI as it is a natural thing that has come to live with us.
Yes.
Now, the other side is cover later on the AI. So the issue of
Question?
that trust will still be there in the parties that they find out that you use AI, why you did not disclose. Fill of disclosure.
Okay. The third, Isaiah, and then we'll come to Amel, and then we'll move to the side of the room.
Thank you very much, Prof. My name is Isaiah from Nigeria. I'm looking at it from a seats perspective. So, for instance, if you look at the centenary principles, two factors that determine what might be a viable seat are the law and ethics. So, given the circumstance that AI is here to stay, and also given the fact that African countries want to promote themselves as viable seats, are we into a situation where laws have to now start either facilitating or regulating the use of AI? If yes, how would that be counterbalanced given the concerns you have raised from an ethical perspective to any of the panelists?
Okay, and the centenary now is 13. The 13th one is technology. Amir.
Thank you. I see that the panel has reflected that the chaos that might result from the use of AI in international arbitration. I wonder what the use of IBA guidelines or for arbitrators encompass the use of AI or might
So the use of IBA,
IBA guidelines for legal,
which of the guidelines?
either legal
Or the
for
conflict?
arbitrators
Okay.
to encompass the issues
Okay.
resulting from the use of AI, or there might be a need to have a new rules
Okay,
that result.
so do they need updating in the context of AI? We have a lovely lady here. Oh, yes.
Hi, morning. Sana Belaid, arbitrator and mediator. I'm on the ICC AI task force. I'm very
Yes.
interested in AI. Actually, I'm not that worried about confirmed arbitrators and counsel. When I think about AI, I think about, yes,
Yes.
resources and how we manage resources as a continent, as a profession. How do we still can make our young trainees and students relevant to the profession? How can they learn the profession if by definition AI is doing what we were
Okay.
doing 10 years ago?
There's somebody. Okay.
Thank you. Good morning, Mohammed Salam. As we spoke about that this system may work well in Europe, but doesn't fit our context. So my question is to Salma is, these features differ from, for example, common law system and civil law system, for example, the predicting the outcome. So we've seen in Europe there available data and also the depend on judgment precedents, but in civil law countries this is a bit different. So do you think this feature differs from common law and civil law system? Thank you.
Thank you. Any more, Dalia? We're in her domain, so
No,
she
no.
uses her.
I'm not abusing. No, no, very
So-
quickly. You touched upon ethics in using AI. Do you think disclosure is enough as an ethical tool, or do you need more like ethical guidelines and so on?
Does anybody else want to ask a question? Prof.
Thank you for the panel. I enjoyed it very much.
Thank you.
Is there practical ways that we can increase the African footprint in this dilemma of inputs and outputs of AI? Thank you.
Perfect. Okay. Any more questions? None. Which is what happens when you say no comments, just questions. Let's start with Salma. Is that okay? So we'll start. If you take 1 minute each and just pick up on any of the questions you want. You don't have to answer everything so that others can.
So I will start by a very interesting question, which is all questions are very interesting, but first is whether we can maybe remove some of the confidential information while inserting these data. And personally, I thought about it, but we can do it in a scale, but we can do it in another. So if I'm generating a timeline, to be useful, I have to submit all documents to have a proper timeline by dates, related information, letters, everything. If I'm submitting, for instance, a transcript that I need to get the inconsistencies inside of it, I have to submit that report. So I don't think that we can maybe we have in the future tools that will help us, hopefully. But at the moment, I don't think that we have, I would say, option that we can use it without disclosing the confidential information. This is from my view. For the IBA rules, what I understand up to date is that there exists only IBA rules on AI, the use of AI mediation, but the other rules are the conflict of interest of other topics are not focused on artificial intelligence. Only mediation has been issued, regulation related to mediation, or the use of AI in mediation has been issued recently by the IBA Committee on Mediation. For the African, bigger African picture, I think that arbitrary institutions in Africa needs to evolve from a technology side and quickly, whether we are talking about case management, virtual hearings, handling digital documents, or data protection. And we will need to strongly invest in integrated technology systems to remain credible and competitive. This is not just about adopting tools, but building infrastructure, governance, and digital trust. And last point related to the common and law system differences, I think that it's more about the technology side rather than the legal part. So I think that the predictive outcomes, I haven't tried it on Westlaw, for instance, to see what would the predictive outcome be. But I believe that we would have the same conclusion for both.
Okay, I need to move on to, Chinecherem, yes, 1 minute. Yes.
Okay, I will try. So someone asked about training of young professionals. In fact, that was on my mind as I was coming this morning, because I remember when I started practice, the first day I came, I was given a task, and that task had me in the library for more than 2 weeks. I went through the law reports, the textbooks, the everything, the English, everything I went through to be able to write that particular address. And I was thinking this morning, these days, I'm 17 years at the bar this year, and I rarely ever need a junior. I'm writing a brief. I have the Law Pavilion, I have the Nigerian Weekly Online, I have LexisNexis. I can write my brief anywhere. I rarely ever need them to do research for me. And I think it's a problem. It's a big problem. But the issue also is some of these people are already, they come already addicted to these machines. So it's like twisting their arm to do otherwise. So I don't know if I have the answer to that problem, actually. I don't know. But
Okay.
It's something we have to think about. And then the duty of disclosure. I have a problem with that. I mean, some of the regulations we have for the institutions that have regulation already talks about the duty of disclosure. But I think, personally, I think it's a misunderstanding of what this is. I mean, as a lawyer and I use an assistant, a human assistant, I don't have to disclose to you that I used an assistant. Judges use assistants all the time for varying level of help, and they don't have to disclose that they used it. I don't think that because it is AI, I mean, a lot of people disagree, but that is my opinion. I think it is an assistant, it is an assistant. So the important thing is that whatever it gives you, you take paternity over, you assume paternity over it, and it is yours. You take responsibility for whatever it has given you. That is what I think.
Great, thank you very much, Louis.
Yes, so I'll try and address a couple of questions. So I think one set can be grouped together. These are effectively, is disclosure enough? Are ethics enough? Do we need regulation? It seems to me that if you're considering it by tool or task, there are certain tasks or practices in the arbitral process for which we already have regimes that we can rely on. For example, if you are using machine translations, there is checks that there can be put in place, checks and balances of the arbitral process for the use of those translations, whether it's done by a machine or whether it was previously done by a firm, might not present much additional risk. If you go on to document review, often there are ways of providing for this in the arbitral process again, in terms of the disclosure of the way that review was conducted and making it replicable by the other side if needs be. So in the case of certain tasks, you can assess the risk of using AI tools might not have increased in the situation that significantly. However, you might consider that there are other aspects of how AI tools might be used, which present increased risk, which the use of traditional tools doesn't. And that's where you get close to the question of whether disclosure is necessary, and if so, how. For example, if you've been using it, as we discussed, legal research, where there is a risk of hallucinations, which might not have previously existed, then that's something which might need to be addressed. The second question I was going to address was opportunity in respect of parties in and representatives on African disputes. The tools are relatively recent and continuing to emerge and are being refined all the time. Their adoption across arbitral jurisdictions is going to be patchy. It's not always going to be universal. And there is an opportunity there for the places and the users of arbitration who are willing to grapple with the sort of questions that we've been discussing, and who can lead the way on the practices and procedures that can emerge and attain legitimacy by achieving the benefits the technology promises. Those are the things we discussed: lower cost, efficiency, and accessibility. And so in that sense, whilst mitigating the risks at the same time. So in that sense, it seems to me that there is certainly an opportunity there.
Perfect. Perfect. So the way it appears that for our panel, what we're saying is that you take responsibility for your use of AI as we continue on this journey in this age of innovation. So we'll leave you with a couple of questions to engage with as we go out for the tea break, and something for you to really keep thinking about. So what will be the impact of AI on access to justice? If you have some jurisdictions wherein you can do the work, or some lawyers who can produce whatever output they want in 1 second, and there's lack of access because of cost or lack of availability of the infrastructure to support the tools, and it takes them 1 week. How do you deal with that? Then the other question is, how are we going to engage with the cultural influences and the response to that? How are we going to deal with that? How are we going to deal with the danger to the use of personal data? The panel is engaged with that. And this whole idea of the need for disclosure, and for our younger colleagues, how do we teach them how to use prompts? Should we be allowing our university, don't forget that I also teach, should we be allowing our universities across the globe to allow students to use AI to get to know? Are you able to tell your universities as practitioners, this is what we need? These are the sorts of law graduates that we're looking for so that they can enhance what we do, which means we have to change the way we train lawyers. It's not rocket science. We have to change the way we teach law. We have to change the way we train lawyers. And what exactly are we trying to get our newbies, new entrants, what are we trying to get them to use? The last thing, just because I've caught sight of Chirag, we spoke on a panel in Kenya, in Nairobi, a few years back now, and we were on an AI panel. And Chirag, then we did a test. And he said to it was ChatGPT. He said to ChatGPT, show me a tiger in the Nairobi National Park. And then we had a beautiful image of the Nairobi National Park and a lovely Indian tiger planted, a photograph planted in there. Now, you laugh, but most of you and most of us, if we didn't know that there are no tigers in the Nairobi National Park, we would take that as authority because it is an image. We saw it. We saw the national park. We saw a tiger. Did you actually see a tiger in the park, or you saw an image of a tiger? I'd like to repeat the story because you have to have eyes for details. And we can't just rely and say, well, I saw the video. What if the video is not what it actually is? I think that's what the panel wants you to go away and discuss. Thank you very much.
Thank you very much, Emilia. Thank you very much for the moderating the session. I think we're going for a short break now, and we'll be back. You can take it. Others go for the break, for the short break, and we'll be back for the second session.